Audthan v. Nick and Duke.
Good afternoon. May it please the court. Elon Dobbs for Audthan LLC. I'd like to request 5 minutes for rebuttal.
Sure.
I want to emphasize up front that the decision on appeal arises from a motion to dismiss, where the allegations in the complaint are presumed to be true and where my client Audthan was entitled to all reasonable inferences. The appellate division majority did not faithfully apply this standard. With this firmly in mind and in this procedural posture, the question before the court is whether landlord's June 2021 letter was a repudiation of the lease. And make no mistake, when the landlord said in June 2021, for the first time, and in the future tense, that it will not and will never sign a cure agreement.
Does the court get to interpret what that letter meant or didn't mean?
To the extent the court can interpret what is not in the four corners of that letter, it must do so in a way that makes all inferences in favor of Audthan. And one of the things that happened.
So you're saying it was okay for the appellate division to interpret the letter at the 3211 stage?
Not in the way it did. I believe that the appellate division said that in the letter, the landlord reiterated its previous reasons for refusing to sign a cure agreement in 2015. That's not so. The letter does not say that.
Couldn't the letter, in fact, have more than one meaning and it's up to a fact finder?
That may be the case. I don't believe, and this is the reason why our allegations about that letter are presumed to be true, and our allegations about that letter, or that landlord's statement, should be taken at face value, which is that according to it, at that moment, no cure was warranted.
At the motion stage where you were.
Correct, at the motion stage where we were. And it may be that at a future time, at trial or at summary judgment, probably at trial where credibility determinations are at issue, what was really in the landlord's mind may be something for the trier of fact, the judge, to determine. And it was error for the appellate division to sort of make a whole host of inferences in landlord's favor about what it meant and what it was really had in mind when it wrote that letter in 2021.
Let me just ask you.
Saying,
sorry, go ahead.
I'm sorry. I just want to know whether your position is that the courts below couldn't look at what was happening in, I think it was 2015, when the landlord first said, that they didn't want to enter into the cure agreement as drafted, whether they weren't allowed to look at that and view that as the beginning of the breach that you're now complaining of.
Look, because it was a 3211 motion, the court is confined to the allegations of the complaint and the documentary evidence that was properly before it. And so to the extent there are allegations in the complaint about what happened in 2015,
yes,
as framed in the complaint, those well-pled allegations are entitled to the presumption of truth. To the extent that the court engaged in a bit of psychoanalysis about what was in the landlord's mind in 2021 when it wrote the letter vis-a-vis its previous conduct in 2015, that's a bridge too far.
I guess my issue, though, is this distinction between a breach and an anticipatory breach. The court is aware, because of the pleadings, of the 2015 activity, which they viewed as arguably a breach of the contract, and that what happened in 2021 is just a continuation of that same breach. Isn't that their line of reasoning to justify what they did here?
That is their line of reasoning, but it's not borne out by the facts that are pled in the complaint. In 2015, what the landlord did was my client tendered a cure agreement to the landlord. The landlord said, no, we're not going to sign this. Why are we not going to sign this? Because it provides for more affordable housing, more square footage of affordable housing than the lease requires a cure agreement to contain. And so therefore, the cure agreement that you gave us does not comply with the terms of the lease. In 2021, shortly after having been enjoined by Supreme Court from attempting to terminate the lease anymore, landlord embarked on a new path. It started writing letters to HPD, falsely accusing my client of committing fraud. And when HPD rebuffed its attempts to get it to rescind its blessing on that cure agreement that had been circulated in 2015, landlord wrote its June 2021 letter. And what it said in that letter is that no cure agreement was warranted, that it will never sign one.
So let me ask you this. Let me change this up a bit, and let me ask whether this is a possible reading of the agreement that you have. And I'm just looking at the contract itself. I don't worry about who said what afterwards, just the contract. You've got somebody who owns a piece of land. They don't really know how to maximize it, to develop it properly, and there's some regulatory issues around it. Your client knows how to develop the land and is going to put up a much bigger building, and the uncertainty is, what is HPD going to do? So you enter into an agreement that provides for a 40 and 48 years, so basically a 100-year lease, right? With the idea that you'll develop it if you can, and they'll turn it over to you for that period of time, and they'll get it back at the end of that. And what you agree to is that, given the uncertainty around what HPD might do, if either of you refuses to go forward with signing what's necessary, the only thing you can do is to try and compel specific performance. Damages are not available to you. Why is that not a reasonable interpretation of the contract?
Well, it's not a reasonable interpretation of the contract because the section that you're talking about, the damage limitation provision, section 3309, applies when a party has a right of approval or consent which may not be unreasonably withheld. Now, that's a concept that is very well worn in landlord-tenant law and in contract law generally. So well worn, in fact, that the parties used it 22 separate times in the lease. We listed those on page 22
right,
of our brief.
But the question is, if it's unreasonably withheld, in fact, that provision itself says wrongfully, I think, right, which is even stronger, I think, than unreasonably, that your remedy is limited to specific performance.
But the parties used the language, the limitation applies specifically in instances where there is a requirement of approval or consent.
That's wrongfully withheld.
Wrongfully withheld. Now, in section 14.01, which
sorry, but isn't that what you're saying happened here? They wrongfully withheld their consent to sign the HPD? They didn't?
It is not at all. In signing the agreement, the landlord agreed that a cure was necessary and that it would cooperate in executing the documents.
But some cure was necessary.
No, but it's more than that. It specifically says it provides what the contours of that agreement are going to be. A 58,000 square foot building that provides for approximately 15,000 square feet. This was signing the lease.
I understand that's in the contract. So give me an example of how you would wrongfully refuse to sign that.
The contract, give you an example.
HPD comes up with a proposal. Maybe it's not 15,000 square feet, maybe it's 16.5, or maybe it's 14.1. Maybe neither of those is wrongful.
That's not the bargain that the parties struck. The bargain that the parties struck is if the cure agreement complies with what the lease says the cure agreement should be, which is that it contains approximately 15,000 and there's a mixed-use building,
then you have
to sign it.
And if you don't sign it, if you wrongfully refuse to sign it, you are limited to specific performance.
But that's not what the contract says.
Isn't it?
It does not. Because 22 separate times in the contract, but not in the obligation where the landlord must sign the cure agreement, section 14.01, it does not use the words, the landlord has the right and the discretion to consent to or approve of this. The landlord, by signing the lease, approved of a cure agreement that contained the following items. In other words, that it provided for approximately 15,000 square feet of affordable housing and a mixed-use building of 58,000 square feet. And the parties waived money damages in other instances where the lease requires consent or approval that shall not be wrongfully withheld.
So those other 22 examples?
Yes, there are 22 examples, but not in section 14.01. And in those examples.
Then I don't understand what 3309 reads on.
3309 tracks a well-worn concept.
I understand. What obligation in the contract does that apply to?
It applies to the 22 separate instances that reference.
But not 1401.
But not 14.01 because the parties knew how to reference that concept. And the 22 instances are things that may arise in the future going forward over the course of this 88-year lease. What are they? They are approval of a lender, approval of a sublessor, whether or not there can be a leasehold mortgage on the property and under what circumstances. the cure and the contours of a cure, what it would entail, were pre-baked in, but also, and acknowledged. If you look at the language of Section 14.01, the parties acknowledge that a cure is necessary.
Is the reason, just to focus on the language of 1401, so is the reason you say it's distinct from the other provision, is it that the words cooperate in good faith and in executing any documents, et cetera, I'm paraphrasing the last piece, that's materially different from the words used in 3309?
Yes, that's correct.
And so what's the remedy for a breach of 1401 under your theory then?
The remedy, all remedies available at common law for breach of that provision are available, because to limit a common law remedy, like a right to damages, requires specific, directly on-point language.
If the parties wanted to subject 1401, if you think that it, as drafted, it's not subject to 3309, what would they have needed to say differently in order to be clearer in your view that it was subject to 3309's restriction?
They would have, like they did elsewhere in the lease, tracked the language and said that when presented with a cure agreement, the landlord has the discretion to approve or disapprove so long as that approval is not unreasonably withheld.
Okay, so the words execute and cooperate in good faith and execute are materially distinct.
Yes, they are. There's this obligation to cooperate in executing the agreements. And
could you, I'm sorry, over here. Could you, I thought I understood in your brief that you made the argument that the injunctive relief is nonsensical because it's no relief at all for this particular type of breach, or did I misunderstand the argument?
The argument is that if this was in fact a material breach that gave Audthan the right to terminate the agreement, and we believe that clearly was, that to the extent that Audthan was able to terminate the agreement and declare it at an end, a sole remedy of injunctive relief of specific performance would be no remedy at all. And in particular here, where the landlord has said, we'll never sign a cure agreement. What that means is that in order to get specific performance, you have to go and negotiate with HPD. You have to obtain new drawings and engineering and environmental studies and all of the tens of millions of dollars it would take to come up with a new cure agreement, present it to them, but the landlord said, I'm not going to sign it.
I thought you moved to compel them to sign it.
We moved them to compel them to sign an agreement.
Could you not have pursued that?
We did in 2015.
Why no, could you not have continued to pursue that? Even in the face of their letter?
We were, in the face of their letter, that was an option that we had, but we also had the option to terminate.
I understand, but so that's an election you made.
Correct, and the lower court held that we did not have that election.
I'm sorry, why did the lower court say you did not have that election?
Because they held that it was a mere continuation of the behavior that had taken place in 2015, and it was new behavior, what the landlord had done. Quite obviously, the landlord went out to HPD.
Well, no, that's on the anticipatory breach, but I think you withdrew your claim for injunctive relief to compel them to sign, right?
That was already pending in 2015. And
Right.
so because what the landlord did in 2021 was fundamentally different. It said, we will never sign any cure agreement, and the cure.
So what is it that stopped you from pursuing to conclusion your request for an affirmative injunction requiring them to sign the existing HPD agreement?
Because prior to that point, the landlord had continuously taken the position that it would sign a cure agreement that did comply with the terms of the lease, that did contain, we had been litigating effectively
I understand
over
that.
over what 15,000, approximately 15,000 square feet means.
You're not saying the court had lacked the power to compel them to sign.
No, of course not. But let's take the counterfactual. Let's say that the trial court said, you know what, landlord is right. This is too many square feet and it doesn't comply with the terms of the lease. Go redesign a cure agreement. But in 2021, they've said, we're not
Just
going.
means you might lose, but I mean, that's
No.
true of anyone.
But in 2021, in their June letter, they said, we're never.
I understand they said that. People say things in litigation all the time. That doesn't mean you can't go to a court and ask them to say they're wrong and we're right.
respectfully, I think we're very far afield of the 3211 scenario where this arose. All of these things are things that the landlord
I don't
can
think this relates
assert
to
at
the we're
trial.
not far afield, I think. I think this relates to the question that Judge Rivera was asking you earlier about why you were saying that there's actually no relief available to you at all. And what I'm trying to probe at is whether there wasn't a form of full relief available to you in the form of specific forms that you affirmatively decided not to pursue.
The question is that if the right of termination arises, then it basically means that you're exercising that right without the possibility of a remedy. And that divests you of a remedy, of a common law remedy that appears nowhere in the contract. And so,
Right. So what I understand you to be saying is, if I have the right to terminate an agreement or to compel specific performance, because I don't want specific performance, I have no real remedy.
that's correct.
Okay? At least I understand where you are.
Okay.
Good afternoon. May it please the court. Jeffrey Turkel for the cross appellant. I'd like to reserve 3 minutes for rebuttal, please.
Yes.
I'd like to start with the sole remedy provision, 3309, which this court has repeatedly talked about. The Supreme Court and all 5 appellate division justices correctly found that 3309 applies to the particular breach alleged here with respect to the cure agreement. Where the courts went wrong was, and let me just say what that agreement says, 3309. It says, under this provision, whenever, very broad, a party unreasonably withholds consent or approval required under the lease, the other party waives to the fullest extent permitted by law any right to damages, and that such party's sole remedy for any wrongfully.
How do you respond to your adversary's argument, as I understand it, that the differences in the text of 1401 and 3309 mean that 1401 is not subject to 3309?
As this court knows from U.S. National Bank and Nomura and AmBank, it's kind of a cottage industry out there to try and evade sole remedy provisions when they rebound against you. 1401 speaks of in terms of cooperation. So what does cooperation mean under this lease? Well, we go to 3310, which is captioned cooperation. And 3310 says that both parties agree to cooperate with the other party in executing any and all documents necessary or appropriate under this lease where requested by other such party and otherwise give its approval to such documents as may be requested by the other party. So the concept of approval is part of the larger concept of cooperation. We get that from 1401, and then 1401 refers us to
But
3310.
I think he's arguing, if I understand, that the language in 3309 is almost like a term of art, right? And that if the parties intended to have it applicable to 1401, then either in 1401 or perhaps in 3310, that those words would have been recited. And so I'm interested in your response to that.
Well, as I said, cooperation is a term that is used in 1401. Cooperation is defined in 3310 as encompassing approval. So I just don't think that it's that much. I mean, I think if you have to cooperate and execute, then you've previously already consented and approved. I think they're all melded within each other. The court has consistently talked about, well, why not go to Supreme Court and get the sole remedy that was given to you? And they did. And when they did, when they moved for injunctive relief 8 years ago, they sought an order directing the landlord to approve and execute the cure agreement, or in the alternative, to review and approve the cure agreement. So they are on record for at least 8 years in this case as saying that the gravamen of our complaint is you didn't approve the cure agreement that was put in front of you, and that puts us into 3309. Once we're in 3309, what do we have? We have a provision that gives them absolutely perfect relief. We don't want to sign, and if they're right that it was unreasonable, they go to court, and they did. They go to court and they say, Your Honor, it's unreasonable, and then the court decides. In this particular case, the court said that there was a question of fact, If I were representing Audthan, I'd be pursuing that injunctive remedy with everything that I had, because if it turned out that it was unreasonable, they'd have their cure agreement, and if it turns out that it was reasonable, the refusal, consent, and approve, then they'd know they had to go back to the drawing board.
But counsel, to get to your adversary's larger point in his argument, this is not just a refusal to cooperate. It's a statement that they're pointing to is a statement that this provision will never be realized because we will never sign that cure agreement, which they say elevates it to a much higher level, a repudiation of the entire contract. And what's most impactful to me in that argument is that this is getting decided at the pleading stage.
Understood, Your Honor.
What gives the courts below, the appellate division here, the right to do that sort of substantive analysis of what the meaning of the 2021 letter is in the context of a motion to dismiss?
There is federal authority, it's cited in our brief, for the proposition that a court can decide a matter of law where the alleged repudiation is in writing. So we have a written record. This is not he said, we have a written record of all the correspondence that went back and forth between HPD. I think what's more important is that when you look at well, let me make one other point. The question here is, was this a breach that falls in 3309? We say it is. If it is a breach that falls in 3309, then 3309 applies and the sole remedy provision applies. It doesn't matter whether the breach is material, non-material, total, partial, or anticipatory. A breach is a breach. Now, an anticipatory breach would give them the right of election, but that's not really involved in this case. So a breach is a breach, whether we call it anticipatory or not. The last thing that I want to say is that—
Well, can we send it back for them to pursue their specific performance remedy?
their specific performance remedy is moot. They moved. They vacated. That's it. It's over. It would just be an advisory opinion.
You mean they vacated the premises?
They vacated the premises. They can't be put back in. They're gone. When courts talk about anticipatory repudiation, they talk about an unequivocal and final refusal to perform. 3309 does not give the landlord that ability to refuse to perform. As Judge Wilson repeatedly said, go to court, use your sole remedy, get your injunction, and if they direct the landlord to sign, then you've got everything that you wanted. You've got—
So is your position there can be no repudiation as a matter of law for that reason?
Yes. Yes. I think when an anticipatory repudiation is
Seems
in
like a
essence—
big carve-out of what we think of viable repudiation claims. That would mean that anytime someone says, I refuse to do X despite my promise in a contract, that there's no repudiation because the other party can go to court and compel you to do it?
Well, it's not that the other party can go to court and compel you. It's that this contract had a specific sole remedy provision that said that is your remedy.
But you're not, are you disputing that if they had, let's suppose they could prove that you repudiated the contract, right? Let's suppose they could, let's take that for granted. Let's say you did repudiate it, right? Would that give them the right to walk away from the contract?
No.
Oh, it wouldn't?
No,
in your
because
view?
their sole remedy— again, it doesn't matter whether it's an anticipatory breach, material breach, partial breach. Their sole remedy, they gave away what they're seeking.
What if they don't want a remedy? That is, to put it differently, let's say that they decide enough time has passed and this is, you guys are just horrible people to deal with and they just don't want to go forward, and they just drop their lawsuit. Can you sue them for not going forward?
It didn't happen, and I don't know
And
if
ask
we—
for specific performance? Because you can't ask for damages under your theory.
No, I think we would have let them go.
Well, so what, I'm not really asking what you would have done, but what you could have done. I mean, it would seem to me that if somebody repudiates a contract, that gives them the right to walk away from it, if the other party the right to walk away from it.
I would disagree. I would say that if you have a sole remedy provision that says you have to get injunctive relief, the fact that a breach is anticipatory rather than material or partial or whatever doesn't take 3309 out of the contract. They waived their right to seek contract damages, which is what they're doing here, which is what they're before
You're
the
saying
court
they
here.
also waived, I think, you're saying they also waived the right to effectively repudiate. So I guess it would be helpful, what's the best case support for that proposition? I take it what you're saying is that where you have a provision like 3309, you essentially can't repudiate because your sole remedy is to go to court under a provision like 3309 and seek specific performance. So if we're going to, if you're suggesting repudiation is contoured in that way, or there's a bite out of it that way, what's the best support for that?
I think the best support is Nomura, U.S. Bank, and AMBAC. Those were sole remedy provisions, and in each of those cases, the plaintiff thought of some very clever and inventive way as to why that sole remedy provision, to which they agreed, should not apply.
If I recall, not specifically, and I might be remembering those cases wrong, but not specifically with respect to whether repudiation was available in the face of a provision like 3309.
Well,
Is that
Your Honor,
right?
in Noble Lowndes, that was a repudiation case, and the court enforced the limitation of remedies provision.
Okay,
It
so
was
if I-
against consequential damages.
If I'm understanding you, your view, based on your responses, both Chief Judge and Judge Halligan, is that they could have sought, and they did, injunctive relief, but then they walked away from that, and then they walked away from the agreement. They picked up and left the premises. And so at that point, they don't get to say, we've suffered financial damages as a result of your anticipatory breach, and we're going to pursue that in court. You're saying they don't get to do that because all they could do is request that we comply with the agreement as written, which is we had to sign off documents, not withhold our cooperation, approve, et cetera, and so forth. But if they walk away, regardless of whether or not they're seeking damages against you, monetary damages, you could have chosen not to pursue an action against them. As you said before, we would have let them go.
We would always have that remedy. That's correct, Your Honor.
So just to kind of clarify what you see as the actions before you.
I mean, I think what we have to look at is what was the intent of the parties at the time that this lease was signed, okay? The idea was that if there was a dispute as to consent and approval, and let's face it, even though the clause is mutual, it's obviously weighing more heavily on the landlord because the landlord is going to be asked to consent and to approve for various documents. The landlord did not want a case where there was a question about whether a refusal to give consent was unreasonable enough. Because if you could get money damages for that in a development deal that's almost 100 years old, the damages could be absolutely astronomical. The landlord did not want to get involved in that. So there's a provision in there, and they said that we waive damages, we waive money damages to the fullest extent allowed by law. And you don't get to evade that by saying, well, it's an anticipatory breach instead of a material breach, instead of a partial breach. 3309 means what it says. This is freedom to contract. 3311
Bad
specific.
faith, and
I'm sorry.
then if there is allegations of bad faith, does that come into play or impact it in
No,
any way?
it doesn't, Your Honor. That's where 60 putback litigation comes in. In Kalish-Charco, the court said, we're not going to enforce exculpatory clauses that purport to insulate a party for their bad acts or gross negligence. And in 60 putback, the court said, well, let's take a look at that. And its analysis was, the first thing we have to do before going into the issue of gross negligence or bad acts is determine whether we really have an exculpatory clause, because the public policy relates to exculpatory
That's your
clauses.
argument here, counsel. Was that your argument below?
Well, we've always argued that 3309 applies and limits
No,
their
this
remedy.
bad faith argument. Did you make
Well,
that
we-
argument below, that this just doesn't apply here?
Yes, under Noble Lowndes, we certainly did, because Noble Lowndes says,
I thought your argument was you didn't engage in bad faith below.
no, we certainly argued Noble Lowndes, and we said that under Noble Lowndes, if there's an element of economic self-interest to the conduct that is alleged to be bad faith, then that doesn't constitute the kind of bad faith or willful act that would cause a court not to enforce a provision between two sophisticated parties that's unambiguous. So that was definitely argued below.
That part of your argument was.
Yes, that is there below. I see my time is up.
You have your rebuttal.
Thank you.
Counsel, could you start on this preservation issue? Was that an accurate recounting of in your view, of what the arguments were below?
No, I don't believe it was. The economic self-interest argument goes to the Kalish-Jarko framework of whether there are allegations that a counterparty engaged in conduct that would vitiate an exculpatory clause. And then the issue of 60 putback, which was not raised in the appellate division and was not raised until the briefing before this court, is whether that framework applies in the context of an exclusive remedy provision. And so that was not raised or briefed below.
In fact, it was almost conceded, I think, that it did.
The framework under which the parties argued was under the Kalish-Jarko and which the courts below rendered their decisions was there, and so that they didn't raise the argument. They raised it here for the first time, and it's a substantively different argument to say I had a financial economic self-interest, and this is a sole remedy clause, not an exculpatory clause.
And so where in the record do we see that? Are you saying that this was just generally the way it was teed up, or is there a specific concession somewhere in the record to that effect?
We cited to the parties' briefs below in our brief here, in our reply brief, so the court can look at those briefs and see that it wasn't in fact argued in that way. And of course, the way the courts below decided the question was without reference to 60 putback and this
But it
framework.
sounds like it's implicit, if I'm understanding you and my reading of the briefs, was that it's implicit in the way the issue was argued as opposed to an affirmative statement along the lines of what you're identifying. Is that fair or no?
I'm not sure I follow you, to be honest. I think that the 60 putback argument, let's call it, is an argument that this is a sole remedy provision, and therefore the analysis under Kalish-Jarko does not apply. That was not an argument that they made below. The argument that they made below was you haven't alleged sufficient
Right.
bad faith
But
conduct.
my question was, the inverse was not stated. Is that right, that 60 putback does not apply? In other words, that as a doctrinal matter, that it's irrelevant?
No, they made their motion to dismiss, and we responded to
Okay,
it.
thank you.
I want to get back to something my friend on the other side said, which is that, which was sort of taken as a given that Section 3309 applies, and that therefore the intent of the parties was a waiver of the right to seek damages. Now, of course, it's black letter law that the intent of the parties is best defined by the language that they used. And in order to get to where the other side is going here, that Section 33.09 applies to Section 14.01, you have to move around a whole bunch to different places in the agreement. You don't have to do that with respect to the 22 separate places in which the specific language, the term of art, as Judge Halligan mentioned it, applies. It would have been very easy to do that in Section 14.01, and the parties did not do that. And they didn't do that because the contours of and the need for, first, the Section 14.01 begins with the parties acknowledge that a harassment finding has been made, that a cure agreement is needed, that no development can happen without such an agreement. It was by signing the lease, the landlord consented and approved of a cure agreement. And what it did in 2021 was said, that obligation doesn't apply to me anymore. And in their brief, they come out and say, what we were trying to do was to obviate our contractual obligation.
Counsel, what are we to make of the fact that prior to 2021, with respect to the obligations that are incurred under 1401, you were seeking injunctive relief, the very remedy that is referenced in 3309?
We were seeking injunctive relief because what landlord had done, it didn't say we'll never sign a cure agreement. It didn't say no cure is warranted. No cure is warranted is a rejection of the fundamental purpose of the lease, which is that you have to get a cure to develop this agreement and to make a declaration of condo. What we thought we were litigating about was, does the cure agreement that we tendered have the appropriate amount of square footage? After which the landlord said, you know, if a redesigned cure agreement, we'll sign it. One that doesn't take away the couple hundred square feet that maybe you've gone over here, we'll sign that agreement. And what they did in 2021 was say, no, 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 the cure isn't warranted anymore because of these accusations that I'm now making against my client and its principals. And that's a fundamentally different thing. That went to the core purpose of the lease. What the landlord did in 2015 was say, you know what, I think this agreement may be giving away too much. And we were litigating about what approximately 15,000 square feet means. And that's a very different thing than the landlord coming back and saying, we'll never do this.
Are you saying that up until that point, you were in 3309 prior to the 2021 letter, but the 2021 letter so fundamentally changes the nature of the breach that you're released from your obligations under 3309?
No, I'm not saying that at all. The 3309 simply doesn't apply. In 2000, we have a common law right to seek.
So you just elected a
We
remedy?
elected to seek specific performance and an injunction compelling them to sign, and money damages for the delay occasioned by the refusal to sign that agreement. Because the refusal to sign that agreement meant that we were carrying the costs of this building, paying rent, doing all sorts of things, keeping employees on staff, and lo and behold, that actually amounted to a great deal of money because the landlord kept attempting to terminate the lease and to prolong the litigation over 6 years.
So is that?
So there were substantial money damages.
Is that a refusal to cooperate, consent, or approve, or all of the above?
It was a refusal to cooperate in executing an agreement, we said. We said that the refusal to sign was pretextual and wrong and wrongful, and there was an issue of fact as to whether that was the case. But
Just to be clear, are you also saying that, let me put it this way, under your view of the case, who had to approve that HPD cure? HPD, the parties, who had to approve? Since you're saying all they had to do is cooperate, so who had to approve?
by signing the agreement, they approved of a cure that provided for the development of a 58,000 square foot building and a permanent creation of 15,000 square feet. Once those two conditions are satisfied, then we comply with the terms of the lease, and the landlord has to sign it. The landlord doesn't get to page through it and say, you know, I have a problem with a provision. The only thing, the only reason that they could refuse to sign was it didn't do what the lease said it had to do in Section 14.
I think I now fully appreciate your argument. You're saying they've already approved the cure and most of the terms of that cure, so they could never not approve because they've already approved.
That's correct.
And that's why it doesn't fit under this provision.
It is the central purpose of the lease, both as acknowledged in Section 14 of the lease and as alleged in the complaint. Whereas in the consent and approval land, getting a sublessor is not the most important thing that my client is going to do.
So, I'm sorry, so since they've already approved, however, when they commit the alleged first brief, they're simply not cooperating, that's what you call that?
They're not cooperating in executing the agreement in the rubric of the lease, in the black letter.
Even though cooperation refers to documents, not the agreement?
They're supposed to cooperate in executing documents that comply with the terms of the lease. And so the only grounds under which they could refuse to sign an agreement, was if it did not comply with the terms of the lease. And here, with respect to a cure agreement, the reasons to comply with the lease had to provide for a condominium of a certain number of square feet and square footage of affordable housing that was approximately 15,000. And landlord, unlike the places where their consent or approval could not be unreasonably withheld, didn't have any discretion there because, as you say, Judge Rivera, their approval and consent was baked in when they signed the lease. This was pre-negotiated, unlike the other things.
I'll be extremely brief, Your Honor. There's no concept of pre-approval in this lease. Anytime a cure agreement was submitted...
What did you agree to?
I'm sorry?
What did you agree to?
We agreed to sign, or we agreed to not unreasonably withhold consent or approval to any document, but we had the right to refuse to do so if we believed that it was inconsistent with the lease, and that's the position that we took since 2016. They went to court, they said it's within the lease, we said it's contrary to the lease. I wish we would have gone to court, I wish they would have pursued it, I wish we would have found out 8 years ago, but unfortunately we didn't. Counsel says in his brief, and he just said, that if you look at the record, we always said, well, if they give us a good one, we'll sign it, we'll sign it, we'll sign it. There's nothing in the record that says that. Absolutely nothing. Check the record sites.
What were you communicating to them the first time?
We were saying we're not signing this because you're asking for more square footage for low.
Affordable housing.
Affordable, thank you, affordable, then that's permitted. We were absolutely willing to litigate that, and they never pursued it. And if they had pursued it, we would be in a totally different posture here.
And the flip side of that isn't, and if you took care of that, we have no other problem with this document? If that's the only problem you identified, and they went about the business of resolving that, would you have to sign?
If the court ruled that it wasn't contrary at that point, we would have had to sign. That's correct. We didn't know about the serial harassment at that time in 2016.
No, I understand you think you've got a different basis for what they claim is the second alleged breach, anticipatory breach, however you want to call it. You said any breach is a breach, so I'll go with that for the moment. But then once you make a different statement, aren't they then able to read that statement for purposes of the motion to dismiss in their complaint as now it is not a question of whether or not we can resolve the dispute, but this is completely off the table, which is contrary to the arrangement we entered into, which is that they would cooperate with the documents as long as it fit whatever categories you all agreed to, right?
Right.
Is that not an inference that can be made? It's a motion to dismiss.
Not if we give 3309 its due and its effect. A breach is a breach is a breach. They're saying we're refusing to consent and approve, whether it's this one or forever and ever. That is where this falls, and their sole remedy.
But would you not agree that there are, yes, a breach may be a breach, but the substance of the breach is what you're debating, right?
Your Honor,
So the first breach is you're not agreeing to this, or you're not cooperating, but they're arguing it satisfies all the requirements. You have no basis not to cooperate. The second one is you've absolutely taken cooperation off the table. You will never sign off on this. There's nothing we can do to get you there.
I think the
It
statement
does seem substantively different, no?
I think that if one ignores the fact that statement that we will never sign it is absurd in view of 3309, which gives them the right to go to court and get us to sign. And even if we refuse to sign at that point, the court would have deemed it signed. They had a perfect remedy under a clause that gave them perfect relief. They decided not to exercise it, and they decided to seek damages that they waived to the fullest extent of the law. Thank you.
Thank you.